Assalamualaikum to all. I hope that all of you are doing safe and sound. For today, we're going to proceed with the second chapter under Administrative Judicial Review. We are going to look into judicial review in administrative law. Right, before that, let's just do some revisions regarding our last lecture. We have discussed on the introduction to the administrative law in Malaysia. As you already know, there are many categories of when you look into the definitions of administrative law. But basically, we can conclude that administrative law in Malaysia govern the functions, powers, duties of government agencies, including the public authority. And apart from that, in the administrative law, it also governs the principles known as a judicial review. What is the function of judicial review? To govern the conduct of the public authority in Malaysia. And beside that, you already know the principles of administrative law, which derive from the rule of law, three aspects of rule of law enunciated by Dicey. There are three aspects. First is no man is punishable or can be lawfully punished unless for the distinguished of law. And then no man is above the law, and each man's individual rights are best protected under the common law, whereby the administrative law will safeguard the basic fundamental rights or individual rights of the citizens. And then we have looked into the doctrine of separation of powers. Okay, as you know, this doctrine is the application of this doctrine is not really suitable to our administrative law, because in administrative law we go beyond of this separation of power. In other words, we let the executive to perform the functions of legislative and judicial. That's why I mentioned that being a public authority, they have power to make certain regulations known as subsidiary legislations, and they have power to make certain decision. Alright? Okay, what else? You learn on the public authorities power. Okay, so they have three main powers: rule-making power, adjudicative power, and administrative or executive power. So today we are going to look into the principle of judicial review. Why we need a judicial review? Okay, next. Okay, this is the learning outcomes for today. First, at the end of the lesson today, you are able to describe the meaning of judicial review. Second, you are able to identify the basis and scope of judicial review. And third, you are able to identify the grounds in which courts may intervene in reviewing administrative action. The third learning outcome is very important, because later I'm going to task you in the problematic question, okay, or a problem-based question. Okay, basically this is the important notes on judicial review. So what is mean by judicial review? Okay, basically it is a form of court proceedings which court will normally exercise judicial review. High court. Okay, so the power is given to the High Court, because High Court has a supervisory jurisdiction as provided by the Court of Judicature Act 1964. So judge will review the lawfulness of a decision or action or a failure to act by a public body exercising a public functions. Okay, statutes have given them, conferred to them powers. Them here referring to the public body or public authority. So in order to make sure that they have exercised the power according to the statute or according to the law, then we need a judicial control or known as a judicial review. Okay, supervisions of administrative decision making in order to ensure fast, effective and powerful way to convince a public body to reconsider a decisions. So they have to make decision according to the law. Okay, the decision made by public body will be upheld if they have followed the law in making decisions. And what if the public authority have not followed the law in making decision or in drafting the subsidiary legislations? So court may grant certain remedy to the aggrieved party. Example of remedy that available in administrative law. So this topic we learn later. So part of the remedies are prohibitions, order and injunctions, a mandatory order or a remedy of declarations. And please take note that this judicial review is only available when there is no other effective means of challenge. So if there is either no mechanisms, okay, no other options, then we will go for the judicial review. So High Court will review the decisions or the law made by the public authority. And when we talk about judicial review or judicial control, it will link us with the doctrine of ultraviolence. Please bear in mind that doctrine of ultraviolence is the fundamental doctrine of administrative law. This is the root of administrative law. And this doctrine emphasizes the powers of the administrative or statutory agencies or bodies are conferred and limited by law. As I mentioned just now, public body must exercise their functions or their powers according to the statute or law. Any exercise of power beyond the restrictions or limits imposed by law will render the action taken or decision so made ultra-vires and therefore null and void. So, when this public authority exercise their functions beyond of the limit, beyond of the powers conferred to them, so their decision or action will be considered as ultra-vires. And what is the effect? If they make subsidiary legislation, if they make decisions, then it will become null and void. Void means that it will have no effect at all. Okay. And the determination of the grounds for review is very important. Okay, because it may render an administrative decision as unlawful or illegal must be examined. Okay, so in order to know whether they have exceed the power, we need to determine the grounds for review. Okay, because we want to review the decision or the actions of public authority. So we must know or we must identify the grounds for review. Okay, next. Okay, under the doctrine of ultraviolence, there are two main issues that we need to discuss. First, in terms of substantive questions, or this is also known from the part of substantive law. The question is whether these administrative actions or decisions are authorized, whether they have performed the actions, whether they have making the decisions according to the law. This is the substantive one. Okay, because substantive we will look into the content of the law or requirements itself, whether public authority have followed all the requirements before they exercise their functions. And this is also means that the part of the law that creates, defines and regulates certain rights. Okay, so remember, substantive means that we go to the law, okay, or the requirements itself, what the power authorized to be done by the public authority. And the second issue, we are going to ask whether they are exercised according to the required procedures, whether they have performed the functions, or whether they have made decisions according to the procedures, according to the manners. So the procedure or procedures requirements involved in implementing the substantive parts of the law. And this is involve a court of law, legislative body, or law enforcement agency. Okay, so please bear in mind that any actions of public authority outside of its powers or beyond of its powers will be considered as ultra-vires. What is the effect of ultra-vires? It will become null and void. Okay, next we continue with the next subtopic under delegations of powers. Okay, before we examining the first power of public authority. Okay, delegation of powers means the conferment of power by one person or body on another to act for him. Okay, this is where under administrative law, public bodies gain whatever power they have by delegations. So they are considered as they gain the power through the delegations of powers by the superior authority. So basically, this public authority, they don't have inherent constitutionally mandated power to act. But this is referring to the delegations of its own power to the relevant body, as can be seen in the case of subsidiary or delegated legislations. Okay, general rule here stating that a delegate cannot delegate. This is the Latin maxims, meaning delegatus non potest delegate. This is the Latin maxims, and the definitions. A delegate cannot delegate because public authority has been delegated. Okay, so they cannot delegate their power. When a power has been confided to a person, he must exercise the power personally unless he has been expressly empowered to delegate it to another, for example, through certain statutory provisions. Okay, so once they get the power from the statute, they have to perform the power personally. Okay. However, in administrative law, there is an exception because the delegations of powers to the relevant experts in the right field may be necessary as occasion demands. So it is depends on the necessity of the case of the circumstance, right? And it also depends on the statute, which lays down the provisions for delegations, the subject matter, the degree of control, and a person or body to whom power is delegated. Okay, for example, public officials who delegate their duties include the Prime Minister, who normally assigns ministerial portfolios to his cabinet or minister. So Prime Minister, he has his own ministerial portfolio, okay, and then he gives all the portfolio, he delegate all the portfolios to the cabinet or ministers. Okay, another example in UITM. Okay, according to University Technology Mara Act 1976, whereby the higher education minister is allowed to delegate the exercise, a discharge, or performance of any of his powers, duties, or functions to the university boards of directors under the Act based on Section 29, Capital A. Okay, so UITM also been delegated by the higher education's minister. But please bear in mind that all the delegation of powers depends on the statute. Okay, depends on the statute, subject matter, the degree of control, and then to whom a body of persons is delegated. Okay, your first case for today, we are going to link this case with the delegations of power, whether delegation of power is allowed. Okay, so you may refer to the case of Fifth against Clark. Okay, the details of the case you may refer to your manual. Okay, these are the facts of the case. Okay, based on the Contagious Disease Act 1870, this is the Act of Parliaments, based on Schedule 6, Paragraphs 5 and 6, it states that, okay, local authority may appoint an executive committee to have all the powers of the local authority for the purpose of the Act except rating powers. So, at the first instance, we understood that public body, local authority, they have power to appoint delegations, okay, an executive committee. And then, executive committee may appoint subcommittees and delegate to them all or any of the powers of the executive committee with or without restrictions. Then, according to the Act as well, executive committee that just being appointed by the local authority also can perform all the powers of the executive committee with or without any restrictions. Okay, then what happened in this case? The local authority of West Sussex County Council appointed executive committee, which later appointed subcommittees and execute the powers and duties under a range of provisions, including the Rabies Order 1887. So, from this situation, we understood that, okay, the first public body, local authority, they appointed or they delegated the powers to the executive committee, which later delegate their powers to the local subcommittees. So this order enable local authorities to make regulations for the muzzling of dogs and for keeping them under control. However, no such regulation were made by the local subcommittee, but the executive committee made an order. So they fail to make the order. who failed to meet the order? The local subcommittee. But the one who made an order is executive committee. So the appellant in this case was summoned for a breach of this order, and he later argued that the order was ultraviolence on the ground that it could only be made by the Chichester subcommittee. So according to the appellant, the order should be made by the local subcommittee, not by the executive committee. So what is the court held? Okay, court held that the delegating power can at any time resume its authority. So in this case, the executive committee has exercised the power which the subcommittee might have exercised but did not, and there is no question of conflict of jurisdiction arise in this case. So at the end, the court decided that the order was valid even though it was made by the executive committee, not the subcommittee. Okay, so next we continue with the first power of public authority.